webinar. For those of you who are health professionals and are hoping for your CPD certificates, please note that we will pick up all of your details from the registration, so it's not necessary for you to type in your information into the chat. We've got all of it for you already, and your certificates will be produced and sent in the next few days. So thank you everyone for joining us, and we're going to proceed as we usually do with these events, and that is that we will have the presentation, and then afterwards there'll be time for questions and answers. We'll probably start off with asking you to capture your questions in the Q&A box, and because it's easier to manage that. And if we have any time at some stage, we might open it for verbal discussion as well, depending on how our time goes this afternoon. And so without further ado, let me introduce you to our speaker, Professor David McCoy-Mason, who doesn't need much introduction to many of you, because he has been involved in health law and ethics matters for a very long time, and is a leader in the field in this country, as many of you know. He is a professor of law based at the Center for Socio-Legal Studies at the University of KwaZulu-Natal, and president of the Commonwealth Legal Education Association. David's published more than 350 articles, contributed more than 70 chapters to books, and co-authored 30 books and manuals in the medical and nursing field. He also writes for the volumes of The Law of South Africa on medical professions and practice, public health, and mental health law. He's also a regular contributor to the South African Medical Journal and the South African Journal of Bioethics and Law. He's delivered over 350 papers at national and international law and medical conferences, runs frequent workshops on human rights and democracy for school teachers, community leaders, youth leaders, women's groups, trade unions, university students, and school children, as well as medical law and ethics workshops for the medical and nursing professions. David has visited over 132 countries, and he is a former member of the HPCSA's Ethics and Human Rights Committee. And with that, David, over to you.
Thank you very much, Kevin, and good evening, everybody. I'm a wee bit of a dinosaur, so I've got some Kelo Sibandi helping me very much with the overheads. What I'm going to do is give you a general introduction then under the POPI Act and its implications, the first part of this talk. And then the second part, I'm going to talk particularly about using the social media and again, how POPI might affect that as well. The slides are pretty detailed. I'm just going to talk to them, but it means you can take them away and you'll have a bit more information at your hands when you leave us. So without any further ado, Sam Keller, can we just put up this first slide, please? Right, so this is our topic for this evening, POPI Act and Obligations of Healthcare Professionals. Next slide. What we're going to do then is just, I'll talk a little bit generally about POPI and then start focusing on the research implications. Sam Keller, your slides. Okay, right. And skip that, next one. Okay, so the main purpose then, those of you, some of you have probably been there. I think there was a seminar earlier this afternoon on POPI, and I think the Medical Research Council has had one as well. So you really getting bombarded about POPI at the moment. But as you probably know, it's really there to regulate the processing and distribution of personal information by public and private bodies, and dealing with the flow across the borders, which is very important for clinical research in this country. And it also deals with some of the research issues as well. We will see about it, although it has a general provision saying that if the information is de-identified, it cannot be reasonably identified, then the Act doesn't really cover that. But in fact, when you look at it, it does, because it lists a whole lot of areas which might be of particular concern to you as health professionals. And you've got to make sure about the de-identification, because in some cases, if it's not in the public interest or it's going to undermine people, and I'll give you an example just now. I don't know if some of you remember that article that appeared in the 2019 SAMJ dealing with the cognitive functioning of coloured South African women. And that was later retracted in 2020 by the SAMJ because although at the micro level it had been approved by a local research ethics committee, if one looked at the bigger picture, it was going to upset people in race relations and so on in this country and might cause discrimination against people as well. And so the POPI Act would also apply in that type of situation as well. And had the POPI Act been in effect, that particular protocol for that study probably would not have been passed unless there were special safeguards, which I'll tell you about later in the POPI Act. The POPI Act itself, of course, has to be read in conjunction with the Constitution, the Promotion of Access to Information Act, PIA, and then the National Health Act and its regulations. And I'm going to briefly mention some of those because I'm sure most of you are used to working with them. Next slide. So this is a takeaway for you. I'm not going to talk about them at this stage, but you know that the National Health Department has done a couple of guidelines on how to deal with ethics in research and how to deal with clinical trials. Health Professions Council's got its guidelines and the Medical Research Council. So you've got these here. They're worth keeping and putting together in some sort of manual if you're doing a lot of research, and just keep them with you in your office. Next slide, please. Okay, so the Constitution just really talks about a general right to privacy. Everyone has the right to bodily and psychological integrity, includes the right not to be subjected to medical or scientific experiments without their informed consent. Okay, that is very clear. But includes obviously means then any collection, store, or retrieval of personal information which might upset people psychologically, apart from medical scientific experiments, those would also be regarded as unconstitutional. And the flip side of that, of course, is that everyone has a right of access to information, which is held by the state. And if it's a state body, you've got an automatic right to that. If it's a non-state body, you've got to show that you're furthering or protecting a right. And that has been echoed in the Promotion of Access to Information Act. And the result of that really means that if you are doing research, and you'll see it later in the Code of Conduct, you're doing research with public money, that research should be available in the public arena. Next slide, please. National Health Act, you all know about this. It provides for research ethics committees, and it applies for a National Health Research Ethics Council, which will look at the bigger picture as it affects the country. And that is the type of situation where maybe in that case I mentioned to you, where the article was retracted, it may well be that the National Research Ethics Council stepped in, even though the local ethics council thought that the research was ethically acceptable. Next slide, please. Okay, so just to tell you, in the National Health Act, there is a definition of research in medical health research, and it talks about biological, clinical, psychological, or social processes in human beings, improved methods of providing health services. That's been controversial very recently in Gauteng, as we know, human pathology, causes of diseases, effects of the environment on the human body, development of new pharmaceuticals, medicines, etc., and development of new applications of health technology. And research, as you probably know, is systematic search or inquiry for knowledge. So it's clearly defined in the National Health Act. Next slide, please. Okay, clinical research activities, again, you'll get a whole lot of these listed as well. Studies that evaluate diagnostic, therapeutic, or preventive interventions or variations in services or practice, includes invasive and non-invasive procedures, as you all know. Examples in obviously surgical interventions, removing body fluids or tissues, administering chemical substances, modifying people's diets or their daily routines, altering the environment, observation. So there's a whole list of what these things could be. All of them, though, should be based on some sort of scientifically sound methodology, and with a good probability that the answers to the research questions will be viable. So that, again, are the sort of things that the Research Ethics Committee should be looking at. Protocols then should also refer to the relevant literature, which you get from a systematic review of the relevant information from laboratories and animal studies. Next slide, please. Promotion of Access to Information Act, I'll mention that to you briefly. That act there is to give us our right of access to information. Again, it's to try and allow people to exercise their human rights more, more fully, if you like. Again, PIA stipulates you've got you need to have a request form, and requester gives it to you. PIA actually, and it's referred to in the POPI Act as well, is supposed to establish information officers, people who can be contacted where people need information. They can charge you a fee, but it's got to be a reasonable fee. They can't make it prohibitive, and they can't put unnecessary sort of obstacles in the way. And where you want information from a private body, you're going to have to try and show that you are furthering or protecting a right or interest. And the Act also says you should create a manual within your organization so that people can contact you and people know what the procedures are. Next slide, please. Okay, the POPI Act provides for a group of people called the Information Regulator, which is an independent juristic or legal body with a chairperson and 4 other members. It's accountable directly to Parliament, and regarding how the POPI and the Access to Information Acts are being implemented. And so what the functions of the regulators are then to educate the public about POPI, monitor how it's being complied with by public and private sectors, consult with interested parties and get involved in mediation where you've got opposing parties, handle complaints, conduct research, report to Parliament, amend codes of conduct, I'll talk about that just now, and in general do anything incidental to that. The codes of conduct we'll come back to, but certain professions and so on, and sections of the community that are gathering information have to draw up a code of conduct which will be approved and disseminated by the information regulator. Next slide, please. Okay, so what has happened here is that the Academy of Science in South Africa has proposed a draft POPI Code of Conduct for Research. And you can have a look at that journal I referred you to there, the Journal of Science. And they came up with 8 conditions that must be satisfied. And these 8 conditions they put into the Code of Conduct are referred to in much more length in the sections of POPI. And I've just put in brackets where the sections are. So the first point is accountability. Responsible researchers and institutions must ensure conditions regarding POPI are complied with. So you've got to comply with the Act. Second one is process limitation. You've got to ensure that there's a lawful basis for processing the information. It's necessary for a defined purpose. It's corrected directly from the data subjects with an informed consent. And we'll deal with some of these matters in a little bit more detail later on. Purpose specification. The collection must be for a defined purpose. It mustn't be kept for longer than is required. It must be then deleted or destroyed when it's not used. You may only retain it subject to certain safeguards. We'll see is that telling the data person that you're going to do it, and also security measures we'll talk about later. Next slide, please. Further processing limitation. Further processing is only allowed if it's done with consent and it's done for research purposes. Again, depends, you'll see later what the conditions in the Act are. Information quality. The information collected and stored must be accurate, up-to-date, complete, and not misleading. And again, you'll see their provision there for data subjects to get the information changed if it's not accurate. Openness. Responsible parties, they're the people who are the researchers or the people collecting the data, must maintain a record of all processing of information, provided if it's being processed only for research, then some of these requirements are not necessary if it's impractical. In the middle of a research project, you can't keep maybe trying to get consent every time you need to make a small change or whatever it might be. We'll talk about that a little later as well. Security safeguards. Responsible parties must ensure that the personal information is kept secure. Confidentiality and integrity is required to prevent breaches of data. Any breaches have to be reported to the information regulator. And then data subject participation. You must ensure that the data subjects are informed of their right to access, correct, or delete their personal information and how to do so. In other words, give them some sort of informed consent. But again, we'll look for research. It might always be possible to do all of this, but what at least we do know from our research ethics committees is data subjects have to be told that they can withdraw from a study at any time that they wish to. Next slide. Okay, so for what I've called the informed consent, what the POPI Act says is responsible parties have to take reasonably practical steps to make sure that the data subjects get the following information for getting a consent. You know, of course, that the National Health Act has a very detailed list of information as well. But this is what they suggest. So you'd have to look at the National Health Act list, which talks about the risks, the benefits, the costs. But this one here adds some useful question. What information is being collected and from what source? Name and address of the responsible party, you the researcher. Purpose for which the information is being collected, whether or not the information is required voluntarily or mandatorily. Mandatorily could only be in terms of some legislation or other. Otherwise, it's always voluntary. The consequences of failing to provide that information and any particular law which requires the collection of that information that would be linked to the mandatory requirement as well. Next slide. Also, the fact that the responsible party may intend to transfer the information to a third country or international organization and the level of protection which will be afforded to that information by that the third party is going to give it to an international organization. You will see again, there are quite detailed provisions here, particularly regarding the question of which research ethics committee. It doesn't matter whether it's been independently approved by an ethics committee overseas. It's also got to be approved in South Africa as well. And then any further information which is necessary in the circumstances to make the processing of the data subject's personal information. A lot of this you probably remember from the COVID pandemic, where we had our local authority was looking, even though drugs had been approved or vaccines had been approved, or tests have been approved by the Americans or Britons or anybody else, our authority also had to approve it to make sure it was ethical and complied with our ethical requirements as well. And so all of this has to be done, though, before the data subject is actually subjected to it. So it's part of that informed consent, if you like. Otherwise, if for some reason it wasn't, they've got to be told immediately afterwards. Reasonably practicable is the wording that the Act used. Next slide, please. Okay, there are some exclusions as well. One of the main exclusions is you cannot research if you do not de-identify your subjects. You have to have them de-identified. So any research which is going to identify the data subject is excluded. You can't do that. Any data information that can be used or manipulated by a reasonably foreseeable method to identify the subject as well cannot be done. So you might be giving certain characteristics about them or their locality, which people would then be able to identify them. That is not allowed as well. And also they can be linked by any other foreseeable method that identifies them. That is also excluded. It's accepted, though, that there's certain research data which cannot be de-identified. Genetic information, for instance, can be re-identified through matching or linking data sets, and where relevant technical or scientific understanding or resources can be used. You take a photograph or something, people can obviously identify that person. They might not know their name, but they'll be able to identify them. And we'll see later that there are provisions about dealing with this in a little bit more detail as well. Next slide, please. Okay, general exclusions then, and I'm going to pick up all of these a little bit later. But first of all, there's a general sort of blanket exclusion here, unless you comply with these sections in the POPI Act, which deal with this. And I've linked some of them there, sections 28 to 33, and you'll see just now in more detail. So if you're talking about religious or philosophical beliefs, you're talking about race or ethnic origin, that's that one I told you about, that retracted article would have fallen into that category. The trade union membership situation, political persuasions of people, health or sex life, biometric information, and criminal behavior relating to commission of an offense, a crime, or the proceedings, a criminal trial or something disposing of such offenses. Next slide, please. Okay, but sometimes these can be processed. So if it's religious or philosophical beliefs are done by some spiritual or religious organization that has those beliefs, then they can do it regarding members of their organization or their employees, if it's going to achieve the aims of their organization. If it's an organization dealing with spiritual welfare subjects, again, they can do it, but provided, of course, that the data subjects don't object. And then the religion or philosophy of life of family members of the data subject as well, provided it's one where they have regular contact with that organization, and again, they don't object to it. But you cannot obviously give this information to third parties or publish it without the consent of the data subject. Next slide, please. Race or ethnicity. Again, this doesn't apply if it's carried out to identify data subjects and it is essential for such purpose. So we'll talk about that later in a little scenario, but whether it's essential that we understand how a particular religious community, say, reacts to an issue which affects their health. And they can help us then assist in trying to develop some sort of method of actually promoting their health or assisting them. That would be in the public interest of them, that we're able to do that. And it might, as in the case of COVID, affect a wider, the general public as well, and be in the public interest. So we'll have a look later at that. And then if you comply with laws or measures designed to protect or advance people who have been disadvantaged by unfair discrimination, again, if it was being done on an affirmative action basis, that also would be acceptable. Again, obviously, you've got to get proper consent. Next slide, please. Personal data regarding persons' trade union membership, again, normally can't be done, except, again, if it's a trade union or the trade union federation and it's doing a survey or something of its members, that's acceptable, or it's necessary to achieve the aims of such a trade union or federation. So again, and it cannot be provided to third parties without consent. All of these, basically, you need consent. Next slide, please. Political affiliation, again, we cannot generally disclose it, but if people are members of that political organization, then one can disclose it if it's necessary to achieve their aims. If you're going to form a political party and you want to know where different constituencies are, you'll be able to get that information. If it's necessary to participate in or engage in recruiting or canvassing for elections like the National Assembly, municipal elections, or a referendum, that might be allowed again. And it's necessary for campaigning for a political party or cause. Again, you need consent. Next slide, please. Okay, dear, this one affects you guys particularly regarding a person's health or sex life. Generally can't be disclosed, but in the case of medical professionals, healthcare institutions, social services, etc., it's necessary for the proper treatment of the data subject or for the administration of the organization, a hospital or whatever it is, then it can be. And again, bodies like insurance companies, medical schemes, medical scheme administrators, managed care, if that process is necessary for them to assess risks, insurance, for instance, or performance of medical schemes, or enforce any contractual rights, the managed care organizations can be done. In the case of schools, it's necessary to provide special support for learners regarding their health or sex life, etc. It's allowed. Again, you've got to look at the section, excuse me, I referred you to section 32. Next slide. Inherited characteristics can't be disclosed unless there's a serious medical interest prevailing, there's some genetic problem in the family or something, or the process is necessary for historical, statistical, or research activity again, in which case that would be de-identified. Next slide, please. Again here, this is just to say again, if it's necessary for processing health, then you can make that, or for the administration of health services. Just repeat it again in section 32. Next slide. Health or sex life again, confidentiality. Now, if you belong to a profession, there's a legal provision, then obviously you have to process it subject to what those provisions are. So if you've got a professional legal obligation, you obviously have to keep it confidential. If you don't belong to a profession, you still have to keep it confidential and follow the provision in section 32(1) as well. Next slide, please. Criminal behavior or biometric information, again, can't be disclosed unless, particularly, you can't disclose it if it's referring to an offense, as we meant before, crime or proceedings in a crime. It doesn't apply, though, if it's necessary to supplement the processing of the information about criminal. You've got a serial sex offender or somebody like that. You've got both sex there and you've got criminal conduct. In that situation, it needs to be, again, in the public health interest dealt with. Next slide, please. Also, again, then, we mentioned that, and also in the case of labor legislation, it might be necessary there to deal with certain information, also in terms of the Labor Relations Act. Next slide, please. Okay, information about children, again, is particularly protected, and as you know, our Constitution protects children as well, but you can't do anything, process personal information about children unless you get the consent of the child. Well, if the child is over 12 years old and sufficiently mature, that they can consent if it's for their treatment or whatever, or the person legally mandated can give them consent. As you know, in the Children's Act, there's a whole list of people, parents, guardians, and others who can give consent, caregivers, and so on. So if it's necessary to establish, exercise, or defend a right or obligation in the law. Again, if one has to do a test on a child because there's an epidemic or something and we don't want other kids to be infected, for instance, that might be necessary there. It's necessary to comply with an obligation of international public law. This is really a reference to the Convention on the Rights of the Child, which our country has signed up to. You have to make sure if there are certain things there or procedures regarding international custody relationships or whatever it is, if it's an international obligation we signed up to, that has to be disclosed if that's a requirement. And then if it's used for historical, statistical, or research purposes, if it serves a public interest and it's necessary for the purpose concerned, it would be impossible or involve a disproportionate effort to ask for consent. Sufficient guarantees are provided to ensure the processing does not adversely affect the privacy of the data subject disproportionately. If already, of course, the data subjects have made their condition public, then that is a reason. If the children have gone public and said, you know, we've all got measles at our school or whatever it might be, they've already put themselves in the arena. And if they've done it on Facebook or whatever, and then they've complied, you've got to comply again with the sections 28 to 33. Next slide, please. Okay, the information regulator also gets involved with children. And even though there is a general prohibition, he can, by people apply by notice, which is also published in the Government Gazette, saying they're about to undertake research involving children for this, that, or the other reason. Then, if it's in the public interest and appropriate safeguards in place to protect the personal information of the child, the regulator can actually approve it. Now, I went to have a look and see if I could contact the information regulator. And they've got a contact us website there, which you can do. But I tried the telephone numbers and they are not operational yet, neither of these phone numbers. So what you have to do is go onto the website and then you can email them your messages or whatever. Next slide, please. Okay, the regulator can impose conditions in authorizing processing of personal information, reasonable conditions regarding, for example, upon the request of a competent person to provide a reasonable means for that. If somebody wants to know, can we review the personal information processed and refuse to permit it further, we can say you can do that, but we can say you're not allowed to process this any further and give notice regarding the nature of the personal information that is processed, how such information is processed, and regarding any further processing practices. So this is what you would be told as responsible party. Review it, got to refuse it, you make sure it's properly processed, and make sure if you're going to do further, what further processing do you want to do. Next slide, please. Other conditions, you must refrain from any action intended to encourage or persuade a child to disclose more information about them than is necessary, given the purpose of whatever the study is going to be, and then establish, maintain reasonable procedures, protect the integrity, confidentiality of personal information collected from children. A lot of this is a repetition of what we said, applies generally as well. Next slide, please. So other situations then, if the prohibition doesn't apply, if the information has already been made public by the data subjects, and again, a responsible person can say, look, this information is very important. It's in the public interest. We've taken safeguards to protect the individual data subjects. Can we then, we notice in the Gazette from the regulator says, okay, you can go ahead. So he can impose, provided they're reasonable conditions in respect of any authorization granted. Next slide, please. Okay, this is where you guys do a little bit. I don't know how we're doing for time. But I want you just to take a couple of minutes. Let's just do scenario one quickly, and let's see if anybody can come up with anything. Otherwise, you can go home and think about it. Medical School A wishes to conduct research into the reasons for vaccine hesitancy regarding the COVID-19 vaccine amongst different religious communities in a large city in order to identify the problem and possible ways of reducing it. The researchers plan to use questionnaires to interview participants and to conduct focus groups in each of the different communities. Do you think such research is allowed under POPI? If so, what conditions do you think should apply? If you don't think it would be allowed, why not? If you've got any ideas on that, just raise your hand. If everybody's a bit brain damaged, having worked all day, we don't get any replies, you can use it as a takeaway. Give you another minute or so. Any raised hands, any chats? No, okay. All right, well, just the other one you can think about as well and think about it later. The Medical School B wishes to conduct research into the use of condoms by sex workers of different races and the incidence of STDs experienced by them and their views on how this can be addressed. The researchers plan to do a follow-up study a year after the solutions suggested by the sex workers have been implemented. Is such research allowed under POPI? If so, under what conditions? If not, why not? Any hands? No. All right, well, what we'll do if suddenly someone gets a brainstorm, don't feel free to interrupt me. Just Kevin can just tell me to stop and I'll carry on. So what I want to move, unless there are any other questions or anything, I want to move now on to use of the social media. And again, show you a bit how POPI has affected use of the social media. So if we can have the next slide, please, Keller. Okay, and if you follow the HPCSA and the social media guidelines in their booklet, which is the guidelines on the use of social media, booklet 17, and you can get it, just Google it, or you can get it electronically quite easily off the net. If you follow that, it covers more or less what POPI requires you to do as well. Next slide, please. Okay, the key objective you all know is your HPCA is supposed to guide the profession and protect the public. We find social media useful, of course, because it can keep us up to date with medical developments, provided it's not a fake news sort of website. It can help you build a professional network and share health-related information with the public. And this is all provided for. You need to also just look at booklet 2 of the health professions series of booklets, because that gives you the professional disciplinary rules of the HPCSA. And these rules apply to any of the discussion we're going to have about the use of social media. Next slide, please. Okay, social media, as you know, can include opinions, information, photos, videos, audios, and I don't have to tell you, I as a dinosaur have to be reminded, but not you younger guys. Facebook, Twitter, WhatsApp, Signal seems to be getting quite popular with the medics. LinkedIn, then you've got content sharing platforms, YouTube and Instagram, which, as you know, are very, very popular. Personal and professional blogs, as well as those published anonymously, internet discussion forum, and then comment sections of websites. Okay, carry on. Definition of social media. Okay, who needs to use these guidelines? Not only healthcare professionals who are qualified, obviously, but students as well. And they are big users of social media, as we know, and they need to also be aware of the consequences of their social media might have on their professional careers, because as we know, employers will often look at you if you've got a Facebook page or whatever it is, they might have a look at that, try and get an idea about you. So it's really to give both students and practitioners an opportunity to understand their responsibilities and obligations. Okay, carry on. We've got a few chats we can talk about later. Obligations in relation to social media then. Again, remember you're covered by your normal professional rules. The fact that you're on social media doesn't make any difference about whether you're acting ethically, whether it's confidential, all that sort of stuff. And you've also then got to contend, of course, with the promotion of access to information and POPI, as well as the common law. You've got them, again, there's a booklet on confidentiality, protecting and providing information. I see somebody's picked up that some of the booklets are in different order, but if you go and look at the one, certainly the most recent one I picked up, I've given you the numbers there, but some of them have different numbers because new sections have been introduced. But if you just look at the title, you should be able to find it. And then again, should also be aware when you're dealing with online sharing of information and so on, that there also a booklet, and again, shown now as booklet 10, with ethical guidelines for good practice in telemedicine, because some of the telemedicine stuff is similar to what people are trying to do online as well. Next slide, please. Okay, so patient confidentiality, we've mentioned it. Your dignity and privacy enshrined in the Constitution. National Act reinforces that. Your health professions, ethical rules of conduct also require that. You can share it with other members of the profession with the patient's consent when you're actually doing it with them as part of the healthcare team. You can do it if you're required, a legal requirement, a notifiable disease or something. You can do it like that. You can do it if you're instructed by a court of law. You can do it in the public interest, or it's going to harm a patient as well. What you've got to be aware of, that it can be inadvertently breached by people who are able to get in and start hacking your pages and so on. So you've got to be very careful. You'll mention later, you need to really separate your personal account from your professional account. And we've explained why just now. But you need express consent of patients before publishing any information about them, and which people can have or where they can be identified. If they're under the age of 12, they can consent. We mentioned earlier, they mature enough. Otherwise, you need consent of a parent or guardian, or for treatment to caregiver. Next slide, please. Okay. Where unidentified data will serve the same purpose, then you should make sure that you do use unidentified data. As you heard, that is what the POPI encourages you to do. Even though you don't mention a patient, if you provide a whole lot of information about them, it might be, and their locality or whatever, it might be possible for people to identify them. So again, you've got to be careful that that's not going to happen. And again, POPI says you've got to take reasonably practical steps to prevent that from happening. So any disclosure of information on social media should really be kept to the minimum necessary. Ensure also that the recipients of that information via social media realize it's got to be kept in confidence and respected. You must be aware, of course, as mentioned earlier, that there's always a risk information can be disseminated by invisible groups or whatever. You need to be able to justify your decisions later if confidentiality is breached. You're going to have to justify what you've done, what steps you took, as POPI asked you to do as well. And Remember, in the case of medical information as well and confidentiality, that confidentiality lasts even after the death of your patient. Then you have to get the consent of the next of kin or the executive of the estate. Remember the furore that occurred when Nelson Mandela's doctor started publishing about Mandela's last days without proper consent. Next slide, please. Okay, so what does POPI do here? POPI, incidentally, follows very closely the general data protection regulation of the EU, which is very similar to what is accepted internationally. And they say in order to avoid misusing WhatsApps, this is in particular, the GDR say you should comply with the principles of data protection, and if you apply it to clinical practice, quality, issue this signpost, quality, be aware of what is required in order to comply with the POPI Act regarding access, deletion, objection, and rectification. That is the point in the POPI Act that data subjects are entitled to have access to the information, to delete information which is wrong, to object to information, and to have it corrected. Information, make sure that patients are aware you're going to share their data with medical colleagues on WhatsApp in order to develop a treatment program for them. Consent, make sure the patients give a proper informed consent. You've got the NHA, you've got POPI telling you as well to share their data with medical colleagues in order to treat them correctly. Confidentiality, ensure that the WhatsApp group respects the confidentiality of the patients concerned and take steps to make sure you and your colleagues' equipment is not vulnerable to unlawful breaches of confidentiality, proper security systems, and data security. Ensure that your data security systems are up to date and they can intercept unlawful breaches of their systems. Next slide, please. Okay, also in using WhatsApp for consultations with medical colleagues, then read the legal notice and privacy policy of WhatsApp and inform your patients about it so they understand what it is before you use it to consult with medical colleagues about them. Make sure your patient's information is kept confidential. Ensure that the personal information is kept safe and confidential, only accessible by medical colleagues concerned, not by third parties. Make sure you're communicating with medical colleagues on their business numbers, not their personal numbers. Again, the same reason when it comes to using personal websites as opposed to professional websites as well. Instead of taking your patient's numbers and adding them to your group, instead use an invite link so your patients can choose whether to join or have their information shared. Kevin and I are working with a private group of hospitals, and on our experience, the patients are not identified by their full names in the WhatsApp groups, and all information for downloading is protected by password anyway. So nobody can just get in and access it without a password where it has to be shared. Next slide, please. Okay, the practitioner-patient relationship. This is another area where you might get into trouble when using the social media, because you don't want it to blur your boundaries of your professional relationship and your personal relationship. So generally, healthcare practitioners advise not to interact with patients via the social media because you can end up with other ethical dilemmas if it starts getting into your personal relationships. The POPI Act says, we mentioned before, health or sex life cannot be shared. And by having, you don't want to find yourself, if you've got access to your patient's social media profiles and they start looking at yours, then you may find that you start sharing their information as well. Healthcare practitioners may choose to share information about themselves with their patients during face-to-face consultations, but you don't get the same level of control over the extent of the content. I mean, the next thing you find is your patients are sending out your personal information all over the place as well. And if you perform a non-medical role in their community, you've got to maintain your appropriate professional boundaries, which can be difficult sometimes because people make demands on you. You should then consider carefully the implications of accepting these types of requests. Next slide, please. Okay, if you get an inappropriate message from a patient via social media, you should politely establish your professional boundaries and explain why you're doing it. If they're seeking medical advice, you should tell them politely, please come for an appointment in person. If they persist sending you messages and things, you should log them, have a paper trail, get advice from HPCSA or your medical defense counsel if you belong. Providing medical advice over the social media is unacceptable, really, whether or not you've got a relationship because of the dangers. If medical advice is shared online, it should be general sort of commentaries, and then people told, go to your local practitioner or whatever, or make an appointment to come and see me. And again, you look at the telemedicine guidelines as well. If you have a look at them, you'll see there's similar things when you've got talking to people over the telephone or whatever it might be as well. If person is not a patient wants medical advice, you've got to send them to go and see their own healthcare practitioner. And you've got to separate, as I mentioned earlier, your professional and social media accounts. So you preserve those appropriate professional boundaries. Next slide, please. Right, another thing that the Health Professions Council is worried about is the profession's image. And so you don't want to bring the image of the profession into disrepute and so on. So be careful about that when you're using the social media. People look on the social media, research stories, potential stories, and you might end up with your information going out to large audiences without even knowing it. And can also harm your employability because, as we mentioned, employers often look to see what's going on the social media profiles of their prospective employees. And they see questionable digital behavior, they might not even bother to interview. So avoid things like taking photographs during surgery, posing inappropriately with weapons or alcohol, making unsubstantiated negative comments about individuals or organizations that you know is against the Health Professions Council anyway, making informal derogatory comments about patients, making comments that can be perceived as racist, sexist, homophobic, or otherwise prejudiced, even if they're done in jest or satire. Because again, they can be taken out of context. Next slide, please. Okay, here, last two scenarios for you to think about. First one, a surgeon celebrates a successful operation to separate Siamese twins by raising a glass of champagne and a toast to the surgical team and the parents of the babies. He posts a photo of the event with his team toasting the event on WhatsApp. Is it ethically acceptable in terms of use of the social media? Is it against the POPI Act? Why not? And I think people are thinking and they're going to chat, so we'll talk later on the chats, question and answer section. Scenario 2, a group of medical students celebrates at a party after writing their final exams. They're intoxicated and some of them are in a disheveled state of dress. One of them photographs the inebriated group, posted on his Facebook page. Is it ethically acceptable in terms of HPCSA guidelines? Is it against POPI? Why or why not? Okay, that's everything I want to say. Kevin, maybe you can open up the floor or come back with some of the chats as well.
Sure. Thanks, David. Thanks for that very comprehensive and insightful presentation. I'm quite sure there are going to be questions. It turns out that there was a setting which was preventing people from putting their hands up. So that's why we didn't get any hands up initially. But some people have responded to the first set of questions in the chat. So I'm going to quickly try and get those for you. And maybe we should start there and then go on. Except now I can't open my chat. Oh, there we go. Okay, so let's see. So Marlene Kruger said, I think that in both cases, that's the first set of cases, research would be possible, but with consent of the participants and in an anonymous way.
Yeah, if it's anonymous, yes.
And with consent, that's...
And obviously, you must have consent, yeah.
And Limpo said, I think in case A, it would be allowed, but not sure about case B.
Okay. All right, and remember now, I mean, so I just come back to scenario one, because I'm just looking at my, remember this research, you would have to show, is there any sort of scientific basis or any basis for saying that people of different religions are doing this? You're going to have to ground your research on proper sort of research into the literature. So first of all, is there literature where different religious groups are actually doing this or not? So obviously you have to do that in addition to what was said. And then is this in the public interest that this is done? Is it going to be for the benefit of that religious community? And is it something that's going to give us new knowledge, which we need to know, because the religion is going to give us insights as to how they think we should actually solve the problem in their communities. Good, okay.
So someone else was concerned about the use of focus groups in the religious group. Sorry, no, sorry, in the second, in case B, they were concerned about focus groups. No, first scenario, they're concerned about focus groups, that's right.
Okay. Well, focus group, I mean, if you're doing it with the religious community in question, which has they've all agreed to it, then it's okay to do a focus group because they are sharing it within their community. You want them to bounce ideas because you're trying to get solutions from them. So it could well be done, yeah.
And the second scenario, David, your...
Okay, so again, it's the same sort of story. Is there any scientific basis to say that some sex workers of different races are using condoms or are not using condoms? Is there any research showing what the STD rate is in these different communities as well? In other words, you've got to have some sort of scientific basis for that. They obviously all have to be de-identified. Again, is it in the public interest and in the interest of the sex worker community in particular that this survey is actually done? Is this something that's going to benefit them, again, as the data subjects? And again, obviously, they will have to consent.
Great, thank you. And the second set of questions. So participants, you can raise your hands now. We should be able to. So if anyone has a response to the first of those scenarios, I don't know, Sam, if you can put those back up again, perhaps the ones right at the end. Great, thank you. So I see some participants have raised their hands and you go to them. So Sitembiso, I'm going to open it up for you to speak. Are you able to? Hello? Okay, so that doesn't seem to be working. Annelies?
Can you hear me?
Yes.
Okay, great. Thank you. I want to ask the professor whether, in view of the requirement that consent should be specific and informed, the fact that it's specific, do we still then can make use of broad consent in research?
No, they say, if you look at the Act, it's got to be an individual consent of the data subjects.
Okay.
You know, it's
Right.
okay. I mean, what you can do is you can have an information session where you're giving them the information, but then you're going to have to sit down with each one and say, okay, do you want to make sure, in other words, you sit with them afterwards and say, have they understood this? Are they actually agreeing to it? Do they understand the consequences and so on? So you can give them a broad introduction, but then you must just go back and make sure that each individual data subject is actually taken in that information, understood it, and appreciate the consequences.
And then for future studies, say they took part in your cancer study and you want to retain their materials and you want to use it for future studies, you have to go back to them and get specific consent, in other words.
You can do that if you don't know at the time. I mean, like this one we mentioned earlier where they want to do a follow-up study or something, you can then tell them that we want to do a follow-up study. Are you okay with that? Now, it would be a good idea just to go back and say, okay, you agree, do you still agree or something, just to make sure, because remember, consent in a way is a sort of ongoing process and people are free to withdraw at any time if they wish to.
Thank you. Thank you very much.
Okay.
Okay, I think then what we'll do is we'll have a look at the questions. We'll come back to these scenarios a little later, because there are a few questions and I think people would like them answered. I'm going to deal with the questions that are in the Q&A and in the chat box first, and then if there's time, people can raise their hands and ask other questions as well. So the first question is from Tulani, who says, what is the legal and medical obligation of the attending medical practitioner when he or she makes a diagnosis on a patient that has a potentially serious medical implication to other related family members? For example, a diagnosis of a tumor or cancer with an autosomal dominant genetic profile.
Okay, it's one of the ones that was mentioned earlier as an exception when you're dealing with genetic information about someone. If it's something, first of all, obviously the patient has to know. If the patient is able, if you're able to communicate with the patient, you have to get the patient's consent. Is it okay for your family to know? We know sometimes, patients and families don't always want to know what's, or the families try and put pressure on you not to tell the patient what their diagnosis is. But it's the patient who calls the shot. So you've got to get the patient's permission to do that. You have to point out the consequences. If you don't do this, then this is what can happen. Now, there is a principle in our law that you can breach confidentiality if there's an endangered third party. So if there's a danger that if they're now going to conceive more kids or something that are going to have this genetic defect or whatever it is, then you would be entitled, again, you have to say to the person, look, I'd like, are you prepared for me to do this? But if you're not, I have to then warn your brother or your sister or whatever, that there's the danger that if they conceive another child, this child might actually have it. I don't know if I've helped you sort of clarify it, but that's a sort of thinking. So the endangered sort of party situation for people who are at risk of getting some genetic defect or other, and if they can be warned about it, then you would be justified to do that. But first of all, you always counsel your patient and try and get the patient's consent first.
Thanks, David. I'm going now to a question in the chat from Shuaib. He says he's an audiologist. Some of our deaf and hard of hearing patients who are not proficient in sign language request communication via text with a preference for WhatsApp. What are your views with regards to this in keeping with POPI and the patient-professional relationship?
Okay, are they doing this at a distance? Can I just clarify? Or are they able to see the patient face to face?
I don't know. Perhaps, Shuaib, you could put your hand up and I can allow you to answer that.
And do they go, for instance, to the nearest clinic or something where they can be given a visual report of the thing? Somebody there?
No. There doesn't seem to be an answer. So I don't know. Should we just go into another one?
Okay.
So a question then in the Q&A from Harriet Etheridge. I'm wondering if patients can violate the rights of a doctor under POPI. Say, for instance, the patient posts a negative review of the doctor on Google Business, names the doctor, says something about the perceived religious beliefs based on what they are wearing. Is that a data breach because it discloses religious PI of the doctor? Because the doctor has not consented or sanctioned the post? Or would this be considered to be in the public interest? So the patient says, I posted this negative review to warn other patients about this doctor, and the inference about his or her religious beliefs is incidental. I ask because getting reviewed is a really scary thing now for many clinicians, and I don't think clinicians are that empowered to respond, because there's a fine line between what would be a breach of confidentiality and what would be acceptable.
Yeah, there's also a fine line sometimes between a breach of confidentiality and defamation. But I'm not, I mean, I take the point about the doctor. The fact that doctor is wearing some religious clothes, I don't think that is justifiable unless the doctor is happy for you to do that. But I'm not sure what the other, what the patient's actually saying. The problem about suing patients, and I've written on this in the medical journal, is that although technically you might have a case if they've said something derogatory about you, the problem is by suing them, that gets back in the public arena, because then the next thing is the newspaper is reporting that you are suing the patient because they called you whatever they called you. So the general, I mean, you have the right to sue someone, for instance, who's defamed you, but tactically it's not always the right thing to do if it's really going to, particularly if the defamation took place several years ago or something, to revive that and let people suddenly have this back in their minds again. Because it becomes news, it becomes big news. If a doctor sues a patient, like a man bites a dog sort of story, it gets into the newspapers. Don't have, you have the right though, POPI doesn't take away that right, obviously. Yeah.
So Bridget asks, for my research, I'll be inviting people to complete a questionnaire. I'll be sending the link on WhatsApp. Are there any specific guidelines for this?
Well, the guidelines, you've got to look at what I said earlier about consent and what you've got to inform them. So all the patients who you're going to send that questionnaire to and require them to do it, you need to inform them, tell them why you're doing it, what it is, all that sort of information they need first. And then, so you're going to send the questionnaire to them in a survey, and then how are you going to get the surveys back? And is the questionnaire going to be password protected? Just have a look at those guidelines I gave you earlier. Yeah.
So Bridget, you should be able to speak.
Sorry, what's?
Bridget Walsh, can you respond?
Yeah, are you able to hear me?
Yes.
Yeah.
Okay, so yeah, thank you. Because the query I had, the questionnaire I want to send, unfortunately, in a later message I explained, it's a group of health professionals that I can't reach individually because of the POPI Act. I can't go through HPCSA, etc. So the only way I can kind of get my questionnaire out is through convenient sampling through the WhatsApp groups. But
Well, just hold it just for a moment, because I think your research ethics committees usually require you to go through a gatekeeper. So you have to find a gatekeeper who would then open the way for you to be able to contact these people.
Okay.
Yeah.
Okay, thank you.
All right. So, okay.
All right, thank you.
Kevin?
Yeah, I'm just looking for the question in this chat. But maybe for now we can go quickly. Actually, my colleague Cornelius has been waiting for some time. Let me allow him to talk. Cornelius?
Richard's hand's still up. I guess she's finished.
You'll need to You'll need to put your mic on. Maybe it's an old hand. Okay. All right. So then, so we go back then to these scenarios, and I'll try and find the responses from people, and then people can raise their hands as well, because I think they're quite helpful in terms of making the theory grounded and sensible for us. So the first one was about the Siamese twins, and he posts this event in which they are having a toast, and the question is this against the POPI Act? Why or why not? So perhaps people in the meantime can put hands up while I try to find the responses in the chat. Someone says first scenario is unacceptable, not giving any reasons. Someone says twin separation is complicated. I think the twin separation will be in the news, so then identifiable, then it's not acceptable. However, if the news indicates the family has agreed to publicity, then it is acceptable. If the family has already released their info, else not. However, if they didn't release the info and the surgeon posts the picture, the hospital files may be accessible and then identifiable. So not acceptable. Don't post just for your own reputation.
Yeah. Okay. And then, of course, you'd have to get the permission of the parents, the surgical team, and anybody else as well. If one was going to, but our general advice would be not to do this type of thing. The next thing people will say, you're going around touting. Yeah.
Sure. Okay. And then the second scenario, I'm trying to see if anyone's responded to that. Scenario 2 is unacceptable as it may be in the to distribute.
Cornelius is with us.
Yeah, can you hear me now?
Yes.
Oh, excellent. Thank you so much, Kevin. So, Professor, there is a question I would like to ask you. Apparently, we are planning a study which requires that we get in touch with previous students. And then someone in the group has an impression that that would be against the POPI Act to get in touch with previous students, to even communicate the study to them and then elicit their consent. And I just wanted to get your own take on that. Is it ever appropriate, or appropriate to get in touch with previous students, and then does POPI Act forbids that?
What sort of research are you guys doing?
Just to elicit their attitude and preferences. And I think it's okay. Yeah, the study really it's about assessing their views about the program that was offered to them, the content of the program itself.
Yeah. Okay. I mean, the general thing would be to send out a general sort of invitation, invite students. Remember, I mentioned there, it's better to invite than to add people to a WhatsApp group or something. You invite them to contact you if they would like to be part of this study. But you need to explain to them what the study is and so on as well. And then invite them to come and join the study, rather than just dumping all the stuff on them and letting them reply. Because if you're going to start accessing their personal information about, where they are, where they're staying, what their names are, and all the rest of it, you will be breaching the POPI Act there. So send out a general invitation. Students would like to get, ex-students like to get involved in the study. This is the aim of this study and so on. Please send me your acceptance to this, and then we will send you a questionnaire or whatever. And then you should password protect that questionnaire when you do send it out.
Thanks, David. Then Nosisa is asking, am I correct that the only POPI compliant way to share patient information on social media is if the information is password protected?
Yeah, I think that is the best, the safest thing to do. And certainly our experience is this as well. I mean, you don't have to give the name and location and so on of the patient. You could just say patient A, you've got patient A or patient B. We are sending information encrypted or whatever it is and password protected, and then they can open it when they do that. That would be the safest way of doing it.
Okay. Then Shakira Holland asks, what are the penalties for contraventions of the Act and how will they be enforced?
Enforcement's a good thing in this country, yeah. I didn't actually look at the penalties, but I'll see if I can find them quickly. I have the Act here. Penalties, any contravention not exceeding 10 years, both a fine and such imprisonment not exceeding 10 years. The fine, doesn't say what the fine is. Go to prison for not more than 10 years or get a fine and imprisonment. And then the less serious offences, you go for 12 months or fine. So if they go to, tell them to go to Google, get hold of the Protection of Information Act and go to section 107. And 107 will tell you if you're going to, and it lists a whole lot of sections, it's imprisonment not exceeding 10 years. And if you look at another whole lot of sections, it's imprisonment not exceeding 12 months. So it depends how serious the offence is. But look at section 107, Google section 107 of POPI and you'll find it there.
Thanks, David. Then Sitan Biso asked a question I realized knew would come up, and that's if a department in a hospital, we form a WhatsApp group where we share patients' details for the purpose of clinical care or management and administration. Is that acceptable? I think you covered it, but maybe you just want to refer them back to that section.
Yeah, just again, what we told you earlier, what you should do there is you shouldn't actually have the patient information just going through on WhatsApp unless you password protect it. You've got some way of protecting it because somebody hacks into your WhatsApp group, they're going to get all this information about the patients. If that patient information is password protected, then they can't get access to that information without the password.
Thanks, David. And I think, if you don't mind, because it's been a question that's been asked a lot in our faculty, we might just want to send out the information from those 2 slides about WhatsApp to heads of departments so that they can share that. Would that be all right with you?
Yeah, absolutely right. Yeah, sure.
Thanks, David. And then Sharon asks, when communicating laboratory results on a patient with the attending clinician on WhatsApp, is it acceptable to give the laboratory number and no other details? The clinician would then have to dig into the laboratory information system, which is password protected, to get the results.
Okay, so does that mean that nobody else can get access to that?
I assume it does, but I'm not sure. Sharon, if you put your hand up, I could allow you to speak.
If someone hacks into that WhatsApp group, can they? You see, even though you don't mention patients, if there's some way of them getting it, but if you've got a tight security system so that the information is protected, then you should be okay. But when you're talking about the patients, you can say patient A, patient B, patient C, or whatever. But make sure the information is password, as long as people can't identify it. And it sounds as if the only way to identify it is to have the password and to open their file.
Thanks, David. And then, are there any POPI issues with sharing images of tissue pathology, organ pathology, or skin lesions, and the like, if there are no identifiers on social media?
Generally, I think if it's de-identified and cannot be re-identified, then the POPI Act says that that's acceptable. Our social media says don't sort of send photos and that. But if it's clear that nobody else can identify that, it's not like a photograph of someone's face, for instance. you photograph someone's face, there might be a way of identifying them. But if it's just tissue, the chances are probably not. But again, I mean, do you want other people then to hack in and use your slides for their own purposes?
Thanks. So Dave, I think we should get back to that last scenario with the medical students, because I'm interested to hear what your take is on it. Seems that most people who've responded said that it would be completely unacceptable for them to do this, and they should not post pictures of students in a state of inebriation on Facebook. So what is your answer?
Well, first of all, you obviously would have to get the consent of all the students if you were going to publish anything on them. But is it likely to bring the profession into disrepute if young doctors are all drunk after writing their exams and they're wearing disheveled clothes? Does that look unprofessional? Does that bring the profession into disrepute? And judging from what I'm hearing from people who've answered it, they seem to think that is not ethically acceptable, because you are harming the reputation of, not only are you harming the reputation of the profession, potential doctors, but you're also going to yourselves probably harm your own chances if someone goes in and identifies you later when you apply for a job somewhere. So we're not going to have this guy, he's going to be a bloody drunkard or something. So I would say it is not advisable to do this, and probably would be regarded as being not acceptable to the profession, as professional people shouldn't get drunk. We know that they do, but they shouldn't, and they shouldn't walk around all disheveled looking.
Great. Well, thanks, David. I think that's it in terms of questions. So thank you, everyone, for attending. And thank you, David, for helping us through what it is quite a lot to take in all at once. The video will be available on our YouTube site. And anyone who has any further questions, please can email them to us and we'll pick them up.
Kevin, you can give them the PowerPoint as well if you want. They can have the PowerPoint if they want it.
Thanks very much, David. So if anyone would like the PowerPoint notes, please just send an email to us and we will sort that out for you. Okay, thanks everyone, and enjoy the rest of your evening.
Thanks. Thank you, everyone. Goodbye, and thanks, Kev.
Cheers, David.